You didn't do the install. You never actually set foot on the property, but your name is on the permit, and now there's a complaint sitting at the licensing board with your license number on it. Here's how that happened. Heat pump demand went through the roof. We got rebates, tax credits, utility programs, everybody upgrading at once. You had more signed contracts than crew though. So you did what half the industry is quietly doing right now. You brought in an outside crew to handle the overflow. Good guys, experienced, but not licensed. You pulled the permits, they did the installs, everybody got paid, right? And now one of those installs has a problem, unfortunately. The homeowner is angry and the inspector has questions and the board wants to know one thing: who actually performed the work on the permit you signed? If you're an HVAC contractor in North Carolina, the next 12 minutes might be the most important thing you watch this year. My name is Nick Gogol. I'm a North Carolina attorney, and my firm, North State Law, focuses on professional license defense. We represent licensed professionals all across North Carolina, including heating and plumbing contractors, in front of their licensing boards. If you hold a heating contractor license in this state, this video is about a specific trap that the current heat pump boom is setting for licensees pulling permits for work performed by somebody else. I'll walk you through what the license actually covers, what the board's rules say about permits and supervision, and the pattern of mistakes that turns a busy season into a disciplinary case. Look, at the end of the day, we're all in business to help our clients out, but we also have to make money, right? And when you're building a business, you gotta be careful. First, why is this suddenly an issue? Heat pumps have been around forever, right? What changed is money and volume. Federal agent energy tax credits and utility rebate programs have made heat pump conversion dramatically cheaper for homeowners, and the industry has been running flat out to keep up. And this is during a skilled labor shortage that already was the worst in a generation. So when demand outruns licensed capacity, the overflow has to go somewhere, and it goes to unlicensed crews working under somebody's license. Here's the part contractors miss. The rebate programs themselves change the enforcement landscape. Most of these programs require a permit and a past inspection before the money actually flows. That means work that used to happen invisibly, cash job, no permit, nobody looks, nobody talks, now generates a permanent paper trail with a licensee's name on it. Every rebate file is a record of who claimed responsibility for the work. The board exists to protect the public from unqualified mechanical work. That will tell you that. That's gas connections, refrigerant, electrical interlocks, combustion air. When something goes wrong, that paper trail answers the board's first question before you ever get to it. Here's the baseline. Heating contracting in North Carolina requires a license from the State Board of Examiners of Plumbing, Heating, and Fire Sprinkler Contractors. I think everybody watching this knows that. And that comes out of Chapter 87, Article 2 of the General Statutes. The statute then divides heating work into classification groups, and the classifications matter because each one covers a defined scope of systems. A residential heat pump changeout sits squarely inside licensed territory. Refrigerant circuits, condensate, electrical connections, ductwork modifications, sometimes gas backup. This is not work the law treats as installer optional. Two concepts do the heavy lifting in every one of these cases, so let me define them now. First, the license attaches to responsibility, not just skill. The licensee is the person the law holds accountable for the work being done correctly. Second, the permit is the public record of that responsibility. When you pull a permit, you are telling the inspections department, the homeowner, and the board, this is my work, performed under my license, under my supervision. Hold on to that second one, because it's the whole ballgame. Now, the rule this entire video is about, that is Title 21, Chapter 50 of the Administrative Code, and addresses permits directly. And the principle is simple. A licensee is not supposed to obtain permits for work that isn't actually his. Pulling a permit for someone else's job, an unlicensed crew, a buddy's side business, a sub you never actually supervise, is treated as what it functionally is, and that's lending your license to someone the law says can't legally do the work. And let's look at a hypothetical. This is not a real client and it's not a real case. I don't talk about those. So let's call this guy Tony. He holds a heating contractor license and runs a 4-man shop in the Triad area of North Carolina. When the rebate wave hits, his install backlog went from 2 weeks to 2 months. A former coworker, skilled, experienced, but unlicensed, offers to take some overflow installs. Tony sells the jobs, pulls the permits, and hands the installs to the crew. He tells himself it's a normal sub-arrangement, no biggie. He drives by a job site now and then. Mostly though, his supervision is a text message. How's it going? 14 installs in, a homeowner's brand new system fails in a July heat wave. She calls up the county, the inspector finds workmanship problems and starts asking, well, who did the install and who was the crew? And with no license to lose, the crew tells the truth. Tony was never there. Now the complaint at the board isn't about one bad install. It's about Tony's name on 14 permits for work he didn't perform and didn't meaningfully supervise. Notice what good intentions that Tony had count here for. Nothing. He didn't set out to defraud anyone. He was trying to serve customers during a boom. But the rule doesn't ask about intention. It asks whose work the permit says it is and whose work it actually was. This is where most professionals get into trouble. And it's rarely the arrangement itself. It's the 4 moves people make once things go sideways. Mistake number 1, supervision on paper. After a complaint, the licensee produces a subcontractor agreement drafted last week and dated last spring, or a stack of site log visits that didn't exist until the board asked. Understand the category shift here. Pulling permits improperly is a rule violation. Manufacturing records after notice is a dishonesty problem, and dishonesty is what boards revoke over. They can't stand it. Mistake 2, the after the fact permit. Work got done without a permit. The complaint lands and the contractor rushes to pull one retroactively to fix it. The permit's date tells the story all by itself. Mistake 3, over-explaining. It happens a ton. The board's investigator calls and the licensee, trying to be helpful, narrates his entire business model, including the parts nobody asked about. He hangs up, having converted a one-job complaint into a business practices investigation. Mistake 4, treating the board like a customer complaint. It gets a casual reply or a late reply or no reply at all. A licensing board inquiry is a legal proceeding in its early stage. You got to treat it as such. The response becomes part of the record, and the tone of that record follows you into every later stage of the complaint. Walk the escalation path with me, because contractors consistently underestimate how far one complaint can travel. It starts with a complaint. Homeowner, inspector, competitor, or a rebate program audit. The board investigates, and that's a written inquiry, records request, likely an interview. Don't have to do those, by the way. If the facts support it, the case moves toward disciplinary action, and the statutes give the board real remedies. They do reprimand, probation, suspension, fines, revocation, and their hearing process ultimately is governed by Chapter 150B of North Carolina General Statutes, although they have their own process within their administrative code and statutes as well. And it fans out from there. The unlicensed crew faces its own unlicensed practice exposure, which carries potential criminal consequences. The rebate program may claw back funds paid on non-compliant installs, and the licensee's insurance carrier starts asking whether coverage even applies to work performed by people who weren't supposed to be doing it. One more thing about the current moment, because rebate era jobs are documented. These cases don't come to the board as one-offs. They come as patterns, a licensee's name on a volume of permits that his actual crew could never have performed. The math itself becomes the evidence. Can't be everywhere, can't do everything all at once. Now the part you can control, because none of this requires turning down work, it requires structuring it honestly. Generally speaking, the licensees who thrive in a boom without board trouble do a couple things. They only pull permits for work their own operation performs and generally supervises. Real supervision, meaning their qualified people are directing the work. They're not drive-by texting. They grow capacity the legitimate way. Hiring crew as actual employees, W-2, under their supervision, or partnering with other licensed contractors who pull their own permits for their own work. They keep job files that reflect reality. Who was on site, who did what, who did it when. Created at the time, not reconstructed at a later date. And when the backlog gets long, they let it be long. A 2-month wait list has never cost anyone a license. 14 borrowed permits can. And if a board inquiry does arrive, in many cases the most consequential window is before your first response. What we often recommend is just straightforward. Get guidance before you respond to the board, not after you've locked yourself into a statement and a story that you cannot claw back out of, right? The risk in one sentence here. The heat pump boom is paying licensees to put their names on other people's work. And every permit is a signed statement to the board about whose work it is. The takeaway here is your license can only be lent out once. After that, it isn't yours anymore. This doesn't mean the board is against contractors making money in a boom. It means the boom is being documented, and documented booms are unforgiving. If you've received a letter or a complaint notice from the State Board of Examiners of Plumbing, Heating, and Fire Sprinkler Contractors, consider getting guidance before you respond, because the first response shapes everything that follows. And if this was useful, subscribing helps us keep putting out educational content for North Carolina's licensed professionals. I hope everybody has a fantastic day.